Lionel, leave the files on the desk and keep your hands where I can see them. You're serving this here in my office?
For 24 years, Lionel Braskett operated without meaningful oversight as a police captain in Taro, Oregon. 38 defendants paid him to make their DUI cases disappear, and not one person checked until now.
Cure everything before anything leaves the room. So somebody finally decided the reports mattered.
He would not be making any phone calls. By the time the federal warrant team finished walking him out of his own precinct, agents from the Oregon Department of Justice had already seized his command computer, his department-issued phone, a locked file cabinet behind his desk, and a personal laptop from the trunk of his unmarked Crown Victoria parked in the captain's reserved space. 38 DUI cases, $850,000 in payments, 24 years of service evaporating in the time it took to read the indictment aloud. The patrol officer who made the call to the Public Integrity Unit had been documenting Braskett's directives in a notebook for almost 2 years before he ever picked up the phone. Before we go any further, I have to ask, how many people do you think have the power to make a DUI arrest just quietly disappear from a prosecutor's desk without anyone outside the building ever knowing it happened? Drop your guess in the comments. And if you're new here, subscribe. We cover the cases that fall through the cracks of mainstream coverage every single week. Lionel Wade Braskett was born in May of 1970 in the agricultural town of Taro, Oregon, the second of 3 sons to a long-haul trucker and a school cafeteria manager. The Brasketts lived in a 100-square-foot ranch house on Aspen Street, 3 blocks from the rail yard, in a neighborhood where everyone's father drove for Consolidated Freight or worked the swing shift at the lumber mill on the south end of town. His father was on the road for stretches of 9 and 10 days at a time. His mother served reheated turkey gravy to elementary school kids for 19 years and came home smelling like industrial dish soap. The family was not poor in any catastrophic sense, but money was counted. Christmas presents were practical. New school clothes came from the Sears on Highway 99 in August and were expected to last the year. Lionel was the disciplined son, the one teachers wrote home about in measured complimentary tones. A 4th grade report card from Hawthorne Elementary in 1980 described him as, quote, polite, attentive, and showing strong leadership qualities with his peers. The report card lived in a manila folder in his mother's hope chest for the next 43 years. He played first base on the Taro Little League team that went to the state regionals in 1982. He earned the Boy Scout Eagle rank at 15, with a project that involved repainting the picnic shelters at Taro Memorial Park over the course of one ambitious summer. He worked summers stocking shelves at Renfro's Hardware on Main Street, where the owner, a Korean War veteran named Bud Renfro, took a particular interest in him. Bud was the first person who said, in Lionel's hearing, that the boy would make a hell of a police officer one day. Lionel was 16 when Bud said it, and he never forgot. He graduated from Taro High School in 1988, ranked 34th in a class of 192. He was not the academic standout. He was the kid the teachers trusted to lock up the gym after a basketball game. The kid the football coach asked to drive the equipment van back from away games. He enrolled at Lynn Benton Community College that fall, taking general education credits while working part-time as a security guard at the Taro Valley Mall. By the 2nd semester, he had decided on criminal justice. In September of 1990, at age 20, Lionel Braskett submitted his application to the Oregon Department of Public Safety Standards and Training in Salem. He passed the entrance physical on his first attempt. He cleared the polygraph. His background investigator filed a report describing him as, quote, a mature applicant from a stable working-class family with strong community references and no indicators of disqualifying conduct. He entered the Basic Police Academy in January of 1991. He graduated 16 weeks later, ranked 11th in a class of 42 cadets. His final evaluation noted that he displayed, quote, sound judgment under pressure, demonstrated initiative on tactical exercises, and worked well with command structure. The Taro Police Department hired him as a probationary patrol officer in May of 1991. His starting salary was $24,160 a year. He bought his first car with cash that summer, a a used 1986 Ford Bronco, $4,200 from a private seller in Albany. He married Cheryl Lynn Whitestone, his high school girlfriend, in October of 1992 at the First Methodist Church in Taro. The reception was held in the basement social hall. Cheryl wore her mother's wedding dress, recut and altered by an aunt who taught home economics at the high school. Lionel wore his dress uniform. They honeymooned for 4 days at the Oregon coast, staying at a motor lodge in Lincoln City because they could not afford a longer trip. Their first daughter, Kayla, was born in September of 1994. Their son, Tyler, followed in March of 1997. They bought their first house, a 2-bedroom bungalow on Sycamore Drive, in 1998 for $96,500 with a 30-year mortgage. His early career evaluations were uniformly strong. His field training officer, a 15-year veteran named Sergeant Mark Donlevy, wrote in his 6-month review that Officer Braskett was, quote, conscientious, attentive to procedural detail, and showed a developing instinct for de-escalation that exceeded what is typical of his experience level. His 1-year evaluation cited, quote, consistent reliability on graveyard shift and a willingness to handle the difficult calls without complaint. At 3 years, he was assigned to the department's traffic enforcement unit. At 5 years, he made detective grade and rotated through the property crimes division. He was promoted to sergeant in 2001 at the age of 31, one of the youngest sergeants in TPD history at that point. The promotion came with a $9,400 annual raise and a shift to second watch supervision. He bought a used 1995 Ford F-250 with the first promotion check, sold the Bronco to his younger brother for $1,000, and started restoring an old 1968 Chevy C10 in the garage on weekends. For the next decade, he was the kind of cop other cops described, without irony, as the backbone of the department. He worked the protests that came through Taro in 2003. He worked the floods of 2007. He testified in dozens of cases. He never had a sustained complaint. His personnel file, by 2010, contained 23 commendations and not a single disciplinary letter. He made lieutenant in 2014. The promotion was unanimous on the command staff vote. He moved into administrative duties for the first time in his career, supervising the patrol scheduling office and serving as the department's liaison to the city's downtown business association. He took a graduate certificate in public administration from Portland State University, attending classes on his days off and using vacation time for the residency weeks. He finished the program in 22 months. His thesis project was titled Discretionary Decision-Making in Patrol Supervision, an Operational Framework. In 2019, at the age of 49, he was promoted to captain and given command of the 2nd Precinct, which covered the city's east side, including the 7-block nightlife corridor along Hawthorne Avenue. The promotion came with a $112,000 base salary, a take-home unmarked vehicle, and command authority over 42 patrol officers, 6 sergeants, and 2 administrative staff. The chief who promoted him, a longtime department veteran named James Ruger, told the city council at the swearing-in ceremony that Captain Braskett represented, quote, the institutional memory and operational discipline that this department needed in a generation of new commanders. The pinning ceremony was held at the city council chambers on the evening of June 11, 2019. Cheryl pinned the new captain's bars to his collar. Kayla, 25 and finishing nursing school, took the photographs. Tyler, 22 and stationed at Fort Lewis with the Army, watched on a video call from his barracks. Lionel Braskett's mother, who had retired from the school district 6 years earlier and was beginning to show the early signs of the dementia that would consume the last decade of her life, sat in the front row and cried. To understand what Lionel Braskett did, you have to understand the part of policing the public almost never sees. The arrest is the visible piece. The lights, the field sobriety test, the cuffs, the back of the cruiser. That part is on the body cam. That part shows up in the local news brief. But the case does not become a case at the moment of arrest. The case becomes a case in the 4 to 72 hours that follow, in a series of administrative steps that happen entirely inside the police department, before any prosecutor ever sees a file. In Taro, the workflow ran like this. A patrol officer effected a DUI arrest in the field. The officer transported the suspect to the precinct for breathalyzer testing on the department's Intoxilyzer 8000 instrument, which was calibrated on a fixed monthly schedule and produced printed evidentiary tickets. The arresting officer wrote a probable cause affidavit and an arrest report, both of which were reviewed by a watch sergeant before end of shift. Physical evidence, including any breath samples retained per protocol, was packaged and entered into the property and evidence room with a chain of custody form initialed at every transfer. Within 48 hours, the report and evidence packet were forwarded to the precinct captain's office for administrative review. This was the procedural step that, on paper, was a quality control function. The captain or his designee checked the report for completeness, confirmed the chain of custody was intact, signed the routing slip, and forwarded the case to the Taro County District Attorney's intake unit for charging decisions. In practice, the captain's review was the single choke point through which every DUI arrest in the second precinct passed before it reached a prosecutor. The captain could send a case back to the arresting officer for, quote, supplemental documentation. The captain could flag the evidence packet as, quote, requiring additional verification. The captain could, with a signature on a single internal form, route a case to an administrative review queue that, by department policy, took priority behind active investigations and was reviewed on a, quote, time-available basis. None of this required any officer to lie outright. None of it required tampering in a way that would leave forensic fingerprints. The supervisory discretion was structural. It was the discretion the department had given Captain Brasket when it gave him the captain's bars, and it was the discretion that, when used correctly, served the legitimate purpose of catching real procedural defects before a weak case wasted prosecutorial resources. Taro's second precinct generated on average between 60 and 80 DUI arrests per month, concentrated heavily in the Friday and Saturday late-night shifts along the Hawthorne nightlife corridor. The corridor had 13 bars, 4 nightclubs, 2 craft breweries with tasting rooms, and a stretch of restaurants with active happy hours. Patrol officers on second and third watch knew the regulars. They knew which intersections produced the most stops. They knew which suspects, on contact, would mention a name, mention a lawyer, mention that a phone call would be made in the morning. The trust framework was simple, and it was the framework every American driver assumes is in place when they get behind the wheel after a couple of drinks. The assumption is that the system processes everyone the same. The assumption is that the difference between a conviction and a dismissal is the evidence and the law, not the wallet. The assumption is that the patrol officer who put you in cuffs at 1:47 a.m. on a Saturday is part of a larger structure that will treat your case the same way it would treat the case of any other defendant arrested under similar circumstances. That assumption is what Captain Lionel Brasket, beginning in the summer of 2021, began to sell. The first case that prosecutors would later identify as part of the structure involved a 43-year-old commercial real estate developer arrested at 11:52 p.m. on August 14, 2021, after running a stop sign at the corner of Hawthorne and 4th. His blood alcohol reading at the precinct came back at 0. 18, more than twice the legal limit. The arresting officer's report was clean. The Intoxilyzer ticket was properly logged. The chain of custody on the breath sample was unbroken. The case never reached the district attorney's intake unit. It sat in the administrative review queue for 7 weeks. When it finally moved, it was routed back to the arresting officer with a note from Captain C's, Brasket's office requesting, quote, clarification on the field sobriety test sequence. The officer prepared the supplemental documentation and resubmitted. The case sat for 6 more weeks. By the time it reached the prosecutor's desk, the breath sample retention period had lapsed. The calibration log for the instrument that night had been flagged as, quote, requiring verification, and the body cam footage had been administratively coded as unavailable due to a server migration that had affected, the department's records would later show, only that single recording and no others from that shift. The district attorney's office declined to file. The developer paid his attorney $18,000 in legal fees. $12,000 of that, investigators would eventually establish, was forwarded to Braskett through the cash and cryptocurrency arrangement. This is what they would later call the pattern. It was not crude. There was no missing file. There was no torn-up report. There was no obviously fabricated evidence problem. There was, instead, a small accumulation of administrative friction, each piece of which was independently explainable, that produced a cumulative outcome no prosecutor could win. The intermediary was a defense attorney named, in court filings, only as co-conspirator 1. He was a Tarot County practitioner who specialized in DUI defense and who had, over the previous 15 years, built a clientele consisting of professionals for whom a DUI conviction was a career-altering event. Doctors with hospital privileges, pilots with FAA medical certificates, commercial drivers with CDL credentials, lawyers with bar admissions, insurance executives, 2 elected officials from neighboring counties. The clientele was the kind for whom a $15,000 legal fee, even one that everyone understood, was not purely a legal fee, was a calculation. The cost of paying versus the cost of conviction. The attorney would meet with a client after an arrest. He would explain that he believed the case had certain, quote, procedural vulnerabilities that he was uniquely positioned to develop. He would quote a fee. The fee, depending on the client's blood alcohol level, prior record, and the strength of the underlying evidence, ran from $9,000 to $40,000. The portion that flowed to Braskett, $3,000 to $25,000 per case, was structured through cash deposits into a small business checking account belonging to Braskett's brother-in-law, who operated a custom auto detailing shop on the south end of Tarot, and through cryptocurrency transfers to a wallet investigators would later trace to a device in Braskett's home office. The method of administrative burial varied case to case. In some cases, Braskett directed the arresting officer to file a supplemental report addressing, quote, observations that should have been documented in the original. The supplemental, when filed, would introduce minor inconsistencies with the original. The prosecutor would identify the inconsistencies as an unwinnable credibility problem. The case would not be charged. In other cases, Braskett used his supervisory authority over the evidence room to flag specific evidence packages as requiring chain of custody verification. The verification request would route the package to a secondary review queue. The secondary review queue had a 6 to 9 month processing backlog. By the time the package emerged, the speedy trial clock was either expired or so close to expired that the prosecutor declined to file. In at least 4 cases that investigators would later identify, the physical evidence packages were processed as missing. The department's evidence room log showed the packages had been logged in, but subsequent retrieval requests returned, quote, item not located. The packages were not found in subsequent inventories. Whether the packages had been physically removed, misplaced, or never properly entered into the storage system was a question investigators would not, in every case, be able to answer. The escalation was incremental. The first 6 months produced 3 cases. The second 6 months produced 8. By the second full year, the structure was processing 2 to 4 cases a month, the frequency dictated entirely by the supply of paying defendants the intermediary attorney could bring through the channel. Braskett's per-case take rose as the structure stabilized. Early cases averaged around $8,000 in payment. By 2023, the average per-case payment to Braskett had risen to approximately $23,000, with the highest single payment, an out-of-state corporate executive arrested at 2:14 a.m. on a Friday in October 2023, totaling $48,000 in attorney fees with $25,000 of that flowing to the captain. The money did not announce itself in the captain's life in obvious ways. He did not buy a new house. He did not purchase a boat. He did not take ostentatious vacations. The Brasketts continued to live in the same 4-bedroom house on Cedar Ridge Drive they had moved into in 2008. Cheryl continued to drive her 2017 Toyota Highlander. Lionel continued to drive the unmarked Crown Victoria the department issued him. What the money did was accumulate. In a safety deposit box at a credit union in the neighboring town of Lebanon, in a cryptocurrency wallet stored on a hardware device in his home office, in cash held in the gun safe in his garage. Forensic accountants would eventually identify approximately $610,000 of the $850,000 in payments, with the balance presumed to have been spent on routine living expenses, absorbed into the household budget across 3 years. The structure was not designed to make him rich. It was designed to make him, by the standards of an Oregon municipal police captain, quietly comfortable in retirement. A handful of patrol officers in the 2nd Precinct noticed the pattern. They noticed because they were the officers being asked to file supplementals. They noticed because they were the officers whose cases were not moving the way their cases usually moved. They mentioned it in passing in locker rooms. They wrote nothing down. They told themselves the captain knew what he was doing, that supervisory discretion was, after all, supervisory, that pushing back on a directive from a 24-year veteran with command authority was not what a patrol officer with 3 years on the job was hired to do. One of them did not let it go. Officer Damian Reyes was 29 years old in the spring of 2023. He had been with the Taro Police Department for 4 years. Before that, he had served 6 years in the United States Marine Corps, including a deployment to Helmand Province as a military police specialist with the 2nd Marine Logistics Group. He had grown up in a working-class Mexican-American family in Salem, the first in his family to graduate college, and he had taken the TPD job because his wife wanted to raise their 2 daughters somewhere smaller than the Willamette Valley capital. His evaluations described him as, quote, conscientious, procedurally meticulous, and exhibiting a strong personal sense of professional integrity. His sergeant, in his Year 3 review, wrote that Officer Reyes was, quote, the kind of patrol officer who reads the entirety of the policy manual rather than relying on the verbal versions passed between shifts. The first directive that bothered him came in April of 2022. He had arrested a 38-year-old anesthesiologist for DUI after a single vehicle crash on Hawthorne Avenue, in which the doctor had driven a BMW sedan into a row of parking meters at approximately 15 miles an hour. The arrest was clean. The breath result was 0. 14. The body cam was clear. Reyes wrote the report and submitted it before end of shift. 3 days later, his sergeant called him in. The captain's office, the sergeant said, wanted a supplemental report addressing inconsistencies in his field sobriety test administration. Reyes asked what inconsistencies. The sergeant did not know. The captain's office had not specified. The sergeant suggested Reyes review the body cam and identify, quote, anything that might have been done differently. Reyes reviewed the body cam. There was nothing to clarify. He filed a supplemental that documented, in clinical terms, the FST sequence he had executed by the book. The case did not move forward. He did not understand why. The second directive came in September of 2022, a DUI arrest of a regional executive for a chain of urgent care clinics, blood alcohol. 19. Single car crash with no injuries. Reyes was again directed to file a supplemental. The supplemental request came with what the captain's office characterized as a, quote, suggestion to consider whether the suspect's statements during transport may have been made before Miranda warnings were properly delivered. Reyes had given the Miranda warning on body cam at the moment of arrest. He filed a supplemental documenting that fact in exhaustive detail. The case did not move forward. The third directive came in February of 2023. Reyes started writing things down. He used a small black moleskin notebook, the kind he had carried in the Marine Corps for his patrol logs, and he documented, in his own handwriting, and in the kind of granular detail his sergeant had described in his evaluation, the specifics of each directive. The date, the case number, the defendant, the substance of the request, the name of the supervisor delivering it. The fact that the request, in his professional assessment, did not align with the case's actual evidentiary record. By the summer of 2023, he had documented 3 incidents that he believed, taken together, represented intentional administrative compromise of cases he had made. He did not yet know that the cases were being burned for money. He did not yet have the framework. What he had was a pattern of directives that he could not reconcile with any legitimate supervisory function, delivered to him with the kind of casualness that suggested the people delivering them had delivered the same directives many times before. We're about to get into the trial. Before we do, if this kind of accountability reporting is what you want more of, subscribe. Cases like this one do not get the coverage they deserve, and the patrol officer at the center of this story did something most officers in his position never do. Stick around for what comes next. In September of 2023, Officer Damian Reyes called a number he had located on the Oregon Department of Justice public website. The number was for the Public Integrity Unit's confidential tip line. He used his personal cell phone. He used a pseudonym. He laid out the 3 incidents in detail. He gave the investigator on the other end of the line the case numbers, the dates, and the substance of the directives. He did not, in that first call, identify Captain Braskett by name. He identified him only as, quote, a precinct commander in a position to direct case handling decisions on DUI matters. The investigator on the other end of the line was a senior public integrity prosecutor named Marisol Calloway, who had spent 11 years building corruption cases against Oregon municipal officials, and who, by the end of that first phone call, understood that what Officer Reyes was describing was either nothing at all or one of the largest pattern of conduct cases the unit had handled in a decade. She asked Reyes if he could come to Salem for an in-person interview. She told him she would arrange the meeting through a confidential channel that would not appear on any departmental log. She told him to bring the notebook. The Oregon Department of Justice opened the case under a sealed file designation in October of 2023. The lead investigator was Senior Special Agent Donovan Rourke, a former FBI Public Corruption Squad supervisor who had retired from the Bureau in 2019 and joined the state DOJ as a contract investigator on a series of similar matters. He ran the case with a 4-agent team and a forensic accountant on detail from the Oregon Department of Revenue. The first task was pattern analysis. The team pulled every DUI case routed through the 2nd Precinct's administrative review queue from January 2021 through October 2023. The total was 1,047 cases. Of those, 1,612 had moved through the queue on a standard timeline, with average time to prosecutor of 7 business days. The remaining 235 had been flagged for administrative review or supplemental documentation. Of those, 89 had eventually been declined for filing by the district attorney's office. The team narrowed further. They isolated the 89 declined cases and identified, in each, the specific reason for declination. They grouped the declinations by category: chain of custody compromise, missing or unavailable body cam, calibration verification pending, evidentiary inconsistency between primary and supplemental reports, speedy trial expiration on cases held in administrative review beyond statutory thresholds. 38 cases stood out. Across those 38, the declination reasons were not random. They clustered. Chain of custody and calibration verification appeared together in a way that, statistically, should not have appeared. The cases shared, across the 3-year window, representation by a small set of defense attorneys, with one attorney appearing in 27 of the 38. The defendants, when financially profiled, showed a distinctive concentration in high net worth professional categories: physicians, attorneys, commercial real estate, executive management, 2 state legislators from neighboring districts. The pattern analysis took 5 months. By March of 2024, the team had a working theory and a list of 38 target cases. They began financial tracing on the attorney intermediary in April. By June, they had identified the small business checking account through which cash payments were being routed. By August, they had identified the cryptocurrency wallet and traced 2 transfers to a hardware device that subsequent investigation determined was located at Braskett's residence. The controlled scenario was authorized in October of 2024. The DOJ recruited a cooperating defense attorney from a neighboring jurisdiction who had no prior connection to the intermediary or to Braskett. The cooperating attorney, equipped with audio recording, contacted the intermediary through a referral channel and presented a fictional DUI case. The fictional defendant was described as a 46-year-old anesthesiologist arrested on a Friday night with a 0.16 BAC and a hospital privileging review on the line. The intermediary returned a fee quote of $28,000, with the understanding that $18,000 would, in his language on the recording, quote, address the supervisory side. He explained the structural framework in detail across 2 recorded meetings. He referenced, by name, the 2nd Precinct captain, who would, quote, handle the routing. He described prior cases handled through the same channel, including specific defendants whose names matched names from the 38-case target list. The marked currency payment was made on November 14, 2024. The intermediary deposited a portion of the cash into the small business account belonging to Brasket's brother-in-law within 72 hours. The cryptocurrency portion routed to the wallet associated with Brasket's home device within 96 hours. The DOJ obtained warrants on November 22, 2024. The search of Brasket's residence on December 3, 2024 recovered $214,000 in cash from the gun safe in the garage, including marked currency notes from the controlled payment, a hardware cryptocurrency wallet containing the equivalent of approximately $186,000, a paper ledger documenting, in his own handwriting, what investigators determined to be a per-case accounting of payments received over a 3-year period, safety deposit box keys for a credit union in Lebanon, Oregon, which on subsequent court-ordered access yielded an additional $147,000 in cash, and a department-issued laptop containing emails to and from the intermediary attorney that, while carefully coded, referenced specific cases by their internal department case numbers. The smoking gun, the piece that closed the case beyond any defense, was the ledger. Brasket had kept his own books. He had kept them in a black leatherette accountant's ledger he had purchased at a Taro office supply store in 2021, and he had recorded each case by date, by case number, by amount received, and by method of administrative burial. The ledger was 42 pages of handwriting in his own hand, matched by departmental handwriting samples to a probability investigators characterized as conclusive. Officer Damian Reyes's notebook had given investigators the framework to read the historical evidence. The intermediary's recordings closed the door. The ledger nailed it shut. The arrest was executed at 6:47 a.m. on the morning of December 9, 2024. Captain Lionel Brasket had arrived at the 2nd Precinct 14 minutes earlier, his standard pre-shift arrival time. He had brewed a cup of coffee from the pod machine in the captain's office break area. He had logged into his command terminal. He had pulled up the overnight shift summary. The 2 Oregon DOJ special agents who entered his office were accompanied by an FBI agent on detail to the Joint Task Force and by the Taro Chief of Police, James Ruger, who had been briefed on the investigation 72 hours earlier under a confidentiality order and who had agreed to be present at the arrest. The chief was 61 years old. He had hired Brasket. He had promoted him to captain. He had said, at the swearing-in ceremony in 2019, that the man represented the institutional memory and operational discipline the department needed. The arrest itself was procedurally restrained. There were no raised voices. There was no resistance. The lead agent identified himself by name and agency. He asked Brasket to stand and place his hands on the desk. Brasket did so without speaking. The agent read the arrest warrant aloud. Brasket: I'd like to speak with my attorney. Agent: That's your right. You can call him from processing. Please don't make any statements until you've spoken with counsel. Brasket: I understand. The chief of police, who had not spoken to that point, stepped forward. Ruger: Lionel. Brasket: Jim. Ruger: Is there anything you want to tell me before they take you out of here? Brasket: I want my attorney. Ruger: I understand. The agent secured handcuffs on Brasket with his hands in front rather than behind, a courtesy occasionally extended to law enforcement defendants at the discretion of the arresting agency. They walked him out of the captain's office through the precinct lobby. 3 patrol officers and a records clerk were present in the lobby. One of the officers was Damian Reyes, who had arrived 20 minutes earlier for the day shift and who had not been told the arrest would happen that morning. Braskett saw him. Their eyes met briefly. Reyes said nothing. Braskett said nothing. They walked him to the unmarked sedan parked at the curb and put him in the back seat and closed the door. The processing at the Marion County Jail in Salem took 2 hours and 11 minutes. He was booked on federal charges of honest services, wire fraud, bribery, obstruction of justice, and conspiracy, with state counts of misconduct in office and tampering with public records to be referred concurrently. His personnel file at the Terrell Police Department was placed on administrative hold pending the indictment, which was returned by the federal grand jury for the District of Oregon at 3:14 p.m. that same afternoon. By the close of business on December 9, 2024, Captain Lionel Braskett had been suspended without pay. The 2nd Precinct had been placed under interim command of a lieutenant transferred in from the 1st Precinct, and a press release had been issued by the Oregon Department of Justice announcing the indictment and the recovery of approximately $547,000 in cash and cryptocurrency from the captain's residence and storage facilities. The indictment was returned by a federal grand jury sitting in Eugene, Oregon on December 9, 2024. It contained 23 counts, 9 counts of honest services wire fraud under 18 U.S.C., Sections 1343 and 1346, 6 counts of bribery under 18 U.S.C., Section 201, 4 counts of obstruction of justice under 18 U.S.C. Section 1503, 3 counts of money laundering under 18 U.S.C. Section 1956, and 1 count of conspiracy. The state counts of misconduct in office and tampering with public records were filed in Terrell County Circuit Court the same week. Braskett retained as his defense counsel a former federal prosecutor named Eleanor Hartline, who had left the U.S. Attorney's Office in Portland in 2018 and had built a defense practice that specialized in white-collar and public integrity cases. Her initial strategy was to challenge the warrant on the grounds that the Oregon DOJ investigation had relied improperly on a state employee informant operating outside his authorized investigatory function. The motion was filed in February of 2025 and was denied by Judge Patricia Vance of the U.S. District Court for the District of Oregon in April. Hartline filed a subsequent motion to suppress the ledger as a Fifth Amendment violation, arguing that the document had been compelled production through the search warrant in a manner that effectively required Braskett to authenticate his own incriminating statements. That motion was also denied. As of the date of this case file, the case remained pending trial, with the trial date scheduled for the fall of 2025 in U.S. District Court in Eugene. The defendant has entered a plea of not guilty to all counts. The estimated trial length per pretrial scheduling order is 6 to 8 weeks. The public record filings released to date include the affidavit in support of the search warrant, redacted versions of approximately 14 of the 38 target case files, the transcripts of the controlled scenario recordings with the intermediary attorney, and the forensic accounting report identifying the $610,000 in traced funds. The Terrell County District Attorney's Office announced in February of 2025 that it would conduct a comprehensive review of all 38 identified cases, with the stated intention of refiling charges in any case where the statute of limitations remained open and the evidentiary record could be reconstructed. As of date of brief, 6 of the original 38 cases had been refiled. 2 had resulted in convictions on amended charges. 4 remained pending. The intermediary attorney, identified in the indictment as co-conspirator 1, was charged separately in February of 2025 with conspiracy, honest services wire fraud, and obstruction of justice. He entered into a cooperation agreement in May of 2025 and has been removed from the active roster of the Oregon State Bar, pending disciplinary proceedings. Braskett's brother-in-law, the owner of the auto detailing shop through which cash payments had been routed, was charged with money laundering and conspiracy in March of 2025. He entered a guilty plea in July under a cooperation agreement. Officer Damian Reyes was named in a citation from the Oregon Department of Justice in March of 2025 for, quote, contributions to public integrity in law enforcement that reflect the highest standards of the profession. He continues to serve as a patrol officer with the Taro Police Department. In a brief statement provided through a department spokesperson at the time of the indictment, he said, quote, I did what I was trained to do. I documented what I saw. I made the call I would want any officer to make if the situation were reversed. The cases mattered. The people who were on the road, because those cases were buried, mattered. I do not consider what I did to be remarkable. I consider it to be the job. Cheryl Braskett filed for legal separation in February of 2025. The couple's home on Cedar Ridge Drive was listed for sale in April. Their adult children have not to date made any public statement. In the months following the indictment, the Oregon legislature introduced 2 bills aimed at reforming the supervisory review process for DUI case routing in municipal departments above a population threshold. The bills, if passed, would require all administrative review actions on DUI cases to be logged in a centralized database accessible to the district attorney's office and to a state oversight board, and would prohibit any single commanding officer from holding sole discretionary authority over the routing of a case past statutory speedy trial thresholds. The 46 chief justices and senior judges of the Oregon judiciary, in a joint statement issued through the Oregon Supreme Court in May of 2025, characterized the Braskett case as, quote, among the most serious institutional integrity failures the Oregon law enforcement community has confronted in a generation, and called for a comprehensive review of supervisory discretion practices across the state's municipal departments. 38 drivers, between 2021 and 2024, walked out of Taro County DUI arrests with no conviction, no license consequence, and no record. An unknown number of them got back behind the wheel. An unknown number of subsequent road safety events trace, in whole or in part, to that fact. Those numbers are not in the indictment. They are not in the press releases. They are not in any of the public filings. They exist only in the spaces between the cases that were buried and the cases that, in a system that worked as designed, would have been prosecuted. The 24-year career of Captain Lionel Braskett ended on a Monday morning in his own office, with his coffee still warm on the desk and his command terminal still logged in. The officer who ended it was working day shift in the lobby when they walked the captain out. This case was disturbing, but the case on the right-hand side of your screen is on a level I cannot describe in words. Click it now.